Welcome. Thank you so much for being with us here tonight for our first of our skills series for 2026. My name is Melissa Wallen. I'm the Director of Exhibitions here at Oolite. And here at Oolite, our mission is really to help artists make art with skills. We're really looking to help artists build professional development so that they can operate and navigate this very fast-paced world that we're living in. And what better conversation than the one that we'll be having tonight? We're thrilled to be partnering with FIU Ratcliffe School. So thank you to our panelists for being here. And thank you to Jacques for making this possible. I'm going to pass the mic over to Jacques so that he can talk a little bit about the school and kind of what they're working on and sort of the research that they're doing, and maybe a little bit about this partnership.
Well, thank you, Melissa. And this is inaugural event that brings two institutions together that really put in the center of our mission position of artists becoming sustainable practitioners who can really go beyond graduate school and survive in the murky waters of the economic world where art may not be valued the way it should be, the creativity may not be valued. So our program roughly for 10 years, and we started right around the corner, right on Lincoln Road 420 with our inaugural cohort of 8 students at that time. And the idea was to really bring creatives and ameliorate value of education that talks about how do you create sustainable practice as a creative? How do you build a set of skills that will allow you to survive in the world where everything is measured by KPIs? And Dimitry was right on board with me starting this cohort of students. It was 3 of us, and Dimitry, me, and Neil Ramsey, as a group of 3 individuals that most likely would never meet anywhere else except at the incubators. When I recruited them, we had an idea of a program that would essentially create a platform ecosystem that would help our creatives to survive. Well, from that cohort of 8, we graduated now over 150 people who run successful businesses connected to a creative practice. And with the generous support of Carl Ratcliffe and Philip Ratcliffe Foundation, we distributed millions of dollars to our students, to our fellows who today are leaders of the different communities who work at different places supporting creative pursuits. And again, this partnership with Oolite means a lot to us because we are bringing our resources, our conversations to the broader community. And again, it feels like a family reunion. I see a lot of familiar faces, a lot of people who work with the program, a lot of people who graduate from the program like Diego. And this is just one of the first events that would probably continue with many, many, many events after. So I'll turn the microphone to Dimitry. Thank you.
Okay. Thank you, Jacques and Melissa and Oolite Arts. It's a pleasure to be with you for this skills program of the series on the practical realities of creative practice. Tonight, we are talking about intellectual property in the age of AI. And I want to start by being honest about something. This is not a reassuring conversation. The law is moving, but slowly. The technology is moving fast. And a lot of what you've been told about protecting your work is either incomplete, out of date, or doesn't account for the specific vulnerabilities that artists face right now. 4 months ago, I moderated a version of this conversation at the Ratcliffe Art and Design Incubator at FIU with the same 2 attorneys. A lot has changed since then, and the most important change is that the Supreme Court declined to weigh in on AI and copyright, which sounds like nothing happened. In fact, it's one of the most consequential non-decisions creatives need to understand. Before we get into that, let me introduce our 2 panelists, both of whom some of you may remember from February, and both of whom have agreed to help us navigate what is genuinely a chaotic legal landscape with honesty rather than false comfort. Somara Jacques. Somara Jacques is an attorney deeply passionate about the intersection of law and creativity. As a founder of Latte Legal PLLC, she assists creative entrepreneurs in protecting and enhancing their businesses through intellectual property protection and registration, including copyright and trademarks. With A background in intellectual property law and a keen understanding of the challenges facing artists, writers, musicians, and other creatives, Somara is committed to providing comprehensive legal guidance tailored to their unique needs. Her practice concentrates on copyright, trademark, business, and technology law, and also offers strategic counsel on licensing agreements, fair use, digital asset management, infringement disputes, contract drafting, and AI integration. Somara also fosters a supportive community through the Latte Lawyer education and information platform, extending beyond traditional legal services with workshops like this one, talks and educational resources to empower creatives with the knowledge to protect their work in an ever-evolving digital landscape. And Andrej Milic. Andrej guides artists and creatives with the tools and knowledge to navigate the complex world of contracts, emphasizing the importance of understanding legalities involved in creative work, ensuring that individuals can safeguard their rights and interests proactively. He sheds light on common pitfalls creatives encounter and strategies to mitigate potential risk. Born in Vienna, Austria, to Yugoslavian parents, Andrej is a director of development at FIU College of Law. He holds a Bachelor's of Applied Science from Miami-Dade College, Honors College, a Master's of Management with a specialization in Justice Administration from St. Thomas University, a Juris Doctor from University of Florida, and an LLM in Intercultural Human Rights from St. Thomas University School of Law. He is a licensed Florida attorney, a participant in the Florida Bar Leadership Academy Class X, and teaches in numerous universities. Welcome.
Thank you.
Okay, the opening scenario, Benedict Cork. I want to open with a story that Somara shared with me because I think it captures everything we're going to talk about tonight more viscerally than any legal concept can. In late February, a British singer-songwriter named Benedict Cork posted a snippet of himself playing an unfinished song called Something Kinda Strange on TikTok. It got over 100,000 plays. A few days later, people started texting him to congratulate him on the release, which was strange because he hadn't finished the song. Eventually, someone sent him the track. It was on streaming platforms under someone else's name. The AI completed version had a full second verse, a bridge, and lyrics that Cork, his words, begrudgingly wished he had written. He got the song removed after a few days, but here's what's important. He had almost no immediate legal recourse. The law wasn't fast enough, and Benedict Cork is one of the lucky ones. He found out. Most artists don't. I'm going to let that sit for a moment, and then I want to ask both of you, what does a story like this tell us about where IP law actually is right now?
If you want, I can start.
You can. I'll go
Because
after you.
you're like a ringer, so I'll start. So I'll give you an anecdote. What I think about is, for a lot of artists and creatives, they look at very reactively somebody's ripping off my work, and it's almost an immediate reaction of, oh my God, how's this happening? What do we do about it? And I had a similar situation happen to one of the clients that I worked with, that one of their clients had messaged them and said, oh my God, I got these really wonderful tote bags with your art on it. And my client said, well, I don't sell any tote bags with my art on it. I just sell oil on canvas paintings. I don't sell reproductions. I don't sell t-shirts. And this client said, well, look at this link. And so my client looked at essentially a lot of their work that they'd posted online had been merchandised by somebody else who was taking advantage of it. And when I met with this client, I said, okay, let's not be reactive in the sense of like immediately, being really upset and losing your ability to produce and what you need to do for your current clients, because this client had a very long order list of people that wanted artwork. And I said, let's not lose focus on that. Let's not, take you out of your creative element, but let's kind of analyze what's really happening. So is your creative product being ripped off? Absolutely. Is somebody else profiting from it? Maybe. So let's look at how many sales are being generated. Really, the number of sales that are being generated were so minuscule that it wasn't really worth pursuing legal action, because the cost of going after these individuals, now of course you can put in complaints and you could go to the websites and say, hey, this is my work, this is somebody that doesn't have a license to sell my work, and get it taken down. But I think for a lot of creatives is like, they look at, oh no, somebody else is going to profit off of all of my hard work, right? and that's almost inevitable in this world, that somebody's going to take something that somebody else created and be able to profit from it. But certain safeguards can be put in place, right? And in the sense also for this artist had no intention or no desire to commercialize their work.
But that's a person.
That's a person, but there's others.
So with AI,
yeah,
how does that translate? Because then,
well, AI was part of this because, for example, all these products were generated through AI to see what the products would look like, right? And we've had AI around for a while. A lot of people think like AI is like so new, but you know those websites where you put a photo and it shows you what they'll look like on a t-shirt and what they'll look out on a sweatshirt and what they'll look like on a hoodie. Well, that was a version of AI because they're superimposing and they can even make it look like a real person is wearing it, right?
Yeah.
And those were kind of the early vestiges of like starting to merchandise and take advantage of. But like that's happening also much quicker. And the big thing is sometimes artists don't even know they're being ripped off, right? They don't even know that their product is being leveraged by somebody else. And at the end of the day, like you got to pick your battles wisely. And you've got to protect yourself in ways which Somara is going to talk more about. Like I'm a very practical person in the sense of like, if somebody's using your work, yes, you don't want it to keep happening. We can get it to stop. There's different avenues to do that. But you also don't want to compromise your creative process and your output over something that's not worth being frustrated about.
So in this case, this was actually a client of yours. And what did you advise them?
So we contacted the websites. We got them to take down the work. And it wasn't a problem anymore after that.
Yeah.
But it appeared to the creative worse than it was, right? And some people kind of jump to conclusion, and it can be, right? In certain circumstances, what if, these tote bags, like the Trader Joe's tote bags, went viral in Europe and sold, that's when it makes sense to litigate, is because there's actually meat on that bone. But if, a lot of creatives and a lot of business people out there are like, oh, we're just going to sue.
So there's a threshold, you're saying, basically, where you have to really think about the return on investment on trying to protect yourself.
Yeah, and a lot of times what's unfortunate with the legal world is that you have to invest to be able to recoup, even though you've been wronged, because, the lawyers need to be paid and the court fees need to be paid. And it's a problem. You got to have a team that's willing to go after these people that have wronged you. So, and a lot of folks out there think like, well, attorney's going to take it on contingency. Maybe, but a lot of attorneys also have families to feed, and not everybody can work on contingency, and it's actually very rare that attorneys will take something on a contingency. So it's also kind of being realistic about like, okay, well, how do we protect ourselves in advance? What do we do if we're put into one of these compromised positions? And also, like, do we need to go down that path of this is catastrophic? Is it really catastrophic, right? Or can we learn something from this situation to help protect in the future? And can we ensure that we make sure that also our community has our back? That's something that I like about social networks, is a lot of your clients and your patrons they want you, they want the original, right? Like they don't want to. And I've seen with the work with, they've gotten their customers to come back, their patrons to come back and license your artwork to this site, because I want to make sure I'm supporting you.
Samara, you were just sharing with me a list of tools. So in this case, it's switched to actual using, in a way, kind of counter AI, maybe?
Yes.
Yes, to protect yourself. Or do you want to add to what Andrej just said?
I want to add a little bit.
Yeah.
I think what Andrej has said works, and I think it's good, but I think maybe I'm a little bit more combative as an attorney.
Yeah, me too. Like I'm not,
I agree
I'm
with
not
that.
vibing with that. Yeah, yeah.
So for me, the reason I did workshops at the beginning is he's right. I charge $250 an hour, which is not sustainable for a lot of artists. So I felt like a lot of times you don't actually need an attorney for the small things. You just need to understand the law, right? Just it's like learning a different language. So I always send a demand letter. Even if it's for $5, I want my $5 back. So I use AI, usually Claude, to create a demand letter for me, right? I've told artists to use that as well, to say, hey.
Oh, and while you're there, I'm going to make a plug for our reference guides that are up here. There are no visuals other than this QR code. So if you haven't downloaded this or opened this, it's actually a web page. And the reason I interrupted Somara rudely is because it was constructed in Claude, and there's also a link there's 6 reference guides in here. One of them is vocabulary based, and then it goes on from there, starting with individual, freelancing, companies, and institutions, and then there is a library. And in the library, there's also a link to all of information on how to be in touch with Somara. And she shared a PDF which she has right here, which is much more granular about what is it called again?
It's AI law and regulation.
AI and law, like where regulation sits with regard to AI law. So there is a lot of information from this QR code, and so I would say just scan it now, and then you can even kind of scroll along as you hear some terms.
The one thing you do want to be careful of with using AI can draft simple documents for you, which are fantastic, but they may not be great as applied. So I had a pro bono client I took on last year that is a sports agent, and he called me, and he's a friend of the family. So I was like, all right, I'll help you guys out, right? And he said, I got a demand letter it was a very large amount of money. It was like $5 million, and they're giving me 48 hours to respond. And this was like on a Saturday. So I'm like, can you just I'll look at it right now, right? Send it to me. I read through it, and it looked like it was drafted by a pretty seasoned attorney, but there were various flaws within it. It was an unreasonable response time. The demand was way too high for the damages that were theoretically incurred. And he was like, what do I do? I said, honestly, this person, you got to look at where is it coming from. This person doesn't really have the capacity to sue you. How do I know that? First of all, with a very basic search, there's a way you estimate the net worth of the individual. So you can estimate the net worth of that individual. Do they have the capacity to litigate? This individual had a very low net worth. All right, it costs a lot of money to litigate. Second thing is a demand letter was signed by this individual, not by a law firm or an attorney. So I know that they didn't retain counsel. And third thing, this person sent the same demand to like some other people. And I was like, look, I would say get ready to litigate, talk to an attorney, maybe, pay for a few hours to say like, hey, this could happen. Let's queue up just in case. But the likelihood is it'll go away. And it went away. It went away, right? So sometimes what can be perceived also as a problem, like you do want to prepare just in case if this person does lawyer up and does file suit. A lot of people threaten to sue but never file suit.
Right, scammers are going to scam. So Somara, sorry, we interrupted you.
No,
Go ahead.
Okay. I think what you're saying is good, right? But I also think that just being passive allows other bad actors to continue to perpetuate the issues that you have. So if you don't send a demand letter, and the demand letters I tell people to send don't ask for like, I want $20 million. I've seen those. But they're usually just stop doing what you're doing, or will assess our available legal options. Leaving that cloud of fear usually helps. You're not saying what you're going to do.
Strategic ambiguity.
You want to invest in a lawyer.
But that's what I'm also going to say. I've had people who've written it and asked me, as you can do ghost legal services, right? You can go ahead and review it. So you have an attorney read over it for you. It costs less than just having me retained. I'm like, okay, well, let me revise this. This is wrong.
It's
this
not
is
going to take you
good.
3 hours.
This
It
is
may take you
bad.
an hour.
It's usually like a third demand letter, 30 minutes at most, right? So I charge less for those. And I encourage people to use it and say, definitely find an attorney. Go to Volunteer Lawyers for the Arts. Like there are so many other places where you can do it. So I see what you're saying, but especially with AI, the problem that we have now is that people can't afford to fight these things. And that's why it's very predatory in the sense that you can't do anything. And if you continue not to do anything, it's going to continue to capitalize and cannibalize and keep going on. So I would prefer, even if you're not going to sue, send a cease and desist, send a demand letter, do the DMCA route, like make them know that you are aware of what they're doing and that you want to make sure that it stops. And if that person knows that's the case, they probably are, it will stop them, but it'll let other people know. I tell people also to post about what happened on Instagram and let them know, hey, I sent a demand letter or I sent a cease and desist. And this person was taking or using my art in a way that I didn't license and approve. They stopped. And I'm putting everyone else on notice that this is something that you don't want to do.
Sometimes the community, for example, I have an artist friend.
I agree with you on that one. The community is like why I posted on Instagram.
Well, no, but it's important because I have a friend, for example, that is a very famous artist that has millions of followers. And his work is constantly being ripped off by other social media pages. and he'll announce it to his community, and they'll go and they'll report it. And when you see all these reports from different legitimate accounts coming in, it's helping police that activity from happening. So totally along those lines.
And do
agree
the
with
platforms respond in that case? The more reports there
Only
are, or
with
do they
pressure.
ignore? Yeah.
With pressure.
Yeah.
I agree with you.
Yeah,
on
because
that.
what happens
Yeah.
is the algorithm picks up that these are actual, these are not bots, these are actual, people reporting this. It's a problem. So they got to do something about it.
So I think you should do a mix of both. Send your demand letter, send your cease and desist, but also utilize your community, because the people who love your art want to make sure they're paying you. You know what I mean? So it's helpful to do both. So you use the PR strategy and the legal strategy.
Okay.
I agree with you on that.
I'm going to move to the terms round. So we're going to use 5 concepts that everyone needs. So we have a kind of vocabulary, that relates to what's going on right now. So the first term is, I don't even know how to pronounce this word, denial of certiorari. Is that right?
Yes.
You say on March 2nd, the Supreme Court declined to hear the Taylor case, the case asking whether an AI system could be a copyright author. A lot of headlines say Supreme Court rules AI can't hold copyright, but that's not what happened. The court didn't rule anything. They just said, not this case, not right now. The lower court decision stands, but this is not settled law from the Supreme Court. Is that right? And so, Andrej, what does denial of cert actually mean for how courts across the country treat this issue going forward? Or Somara,
So
either.
we want to look at mootness or ripeness, right? So oftentimes a court will not address an issue because it's not ripe. Think of a fruit. You're not going to eat an apple when it's not ripe, because you're not getting that juicy, sweet apple, right? And you're like, we may want to leave it a little bit longer on the branch. That's how courts look at issues. They're like, is this really an issue that's ready for us to review and rule on? Has it become such a persistent current problem, or do we punt it for a better time when it's evolved a little bit more? And I'll let Somara talk on that, but that's the way that I view it, is in the sense that the courts will say, not now.
Okay.
We're not saying we're not going to look at it, but we're not going to look at it now.
So there's a ripeness for these issues. Okay, I'll leave that just hanging. We'll ignore whatever that means.
Right is we could go hours down the right path. Right?
Number 2, human authorship requirement. Somara, you say U.S. copyright law requires a human author. The Copyright Office confirmed this in 2025. Prompts alone are not sufficient to claim authorship. You have to show meaningful human creative contribution. The question nobody answered yet is, how much is enough? Somara, for an artist in this room tonight who uses AI tools in their work, what does sufficient human contribution actually look like in practice? Is there a rule of thumb?
Unfortunately, no. But there is a way to look at it, which is appreciable and de minimis.
Okay.
Appreciable means that you actually have the AI acting as an artist. As de minimis means that it's just doing technical things, like if it adds captions, if you have videos, or if it's changing the background slightly, right? But if it's actually inputting the AI, I don't know if you know about Ben Affleck. He has an AI company that generates backgrounds and everything for studio production. So now you can save money because you are, let's say, on a studio like this, right? The background's completely white, and then we're the actors here, right? And then we're just sitting in the chairs, but now we have a whole coffee shop behind.
You're acting like this is theoretical, but this very background was created this way.
No, it wasn't.
Yeah, it was. Just earlier, you came in just after.
Really?
Yeah.
He likes to mess with me.
But also it's this notion of it when you see it type of deal.
So wait,
right?
so Ben Affleck,
But that would be considered appreciable, because
Okay,
you're creating the art.
Okay.
De minimis is when you are just using it to help refine what you've already done, right? So that's what I tell artists to look at. Are you treating the AI as a partner with your art, asking it to create things for you, adding elements for you, or are you asking it to be a technical editor, right? If you can do that, that's usually a really good way for you to self-audit if this is appreciable or de minimis.
Okay.
So for instance, I don't know if anybody reads, have you heard about Shy Girl, the book?
Oh, yes, okay. Absolutely.
I guess they're on a lot of Wattpad videos. But they have fan fiction on places like Wattpad and these other forums.
And they got a big publishing deal.
She got a huge
with Random House or
I forgot which one.
One of
but
the
it was
big
in
five.
Europe.
One of the big five,
She created a book. It's called Shy Girl. It did really well on TikTok. She got a publishing deal, which was amazing. So everyone's happy for her. And then there was somebody who was a consultant in the publishing world who used this random AI checker to see how much was generated by AI. It was like a 78% score or something like that when it came back. But she had given it to an editor, her work. The editor had used AI on her work. And so when she got it back, right, now it looks like she wrote it with AI, she didn't. So it's one of those things where you have to ask, if you're asking for help, you know, what did you use? What kind of sources were you used? And there's really no way to, well, there is some if you look at the metadata, but it's very difficult to find if somebody had inputted in AI or not. Plus the veracity, which means like the truthfulness of that score, is being questioned because it looks like the person who was the consultant on this particular case was friends with somebody who had an AI company. And that AI company, the friend that he has, was in sales. And so she's like, use our system. And so that's the system he used, but there's no way to verify where they got their data, how they come out with their outputs.
So it gets really tangled. I mean, there's a section in our guide, or one of our reference guides, which has to do with either it's in the freelancing section or the company section, where you're talking specifically about this issue, like where does the responsibility lie when AI is used somewhere in the stream? So if I'm a freelancer and someone hires me and I'm to do a logo, which I've done, you know, but I've never used AI, but let's say I did, and I turn in the logo, the contract with the company now should have an AI clause that either requires disclosure or prevents, refuses, you know, and maybe negates liability if, in such cases, you know, right? So contracts are really important here, right?
Agreed.
And in this case, so there's another dimension I think that I remember with this story. I think Shy Girl is African-American.
Yes.
And there's another author, I won't even name, who was on the Oprah Club, who had to apologize at one point, who says, I use AI in my work, no problem, and discloses no repercussions. And there were, it wasn't just even African-American woman versus white man in this case. He has no repercussions for any of his, because he's being kind of, you know, upfront about it.
He disclosed,
and she is like hammered before the story even gets out, and her book deal was pulled.
Yes, it was.
Right.
Yeah.
Yeah.
So I mean, for her to, this is why I'm saying, going back to the demand letter, going back to the cease and desist, going back to these legal things. I know as artists, nobody wants to deal with legal. I get it. I have a bunch of art clients. I know that's something that feels, A, it's scary, B, it feels like you can't do anything, and C, it's a lot of stress and work to send demand letters and to send things out. But just making sure that you have things proactively done can be helpful, right? Having your contract with, you know, something about AI would be helpful. Making sure that you send a cease and desist, even if it's for a small use, just to put people on notice that they shouldn't be doing it, is helpful. So appreciable and de minimis, as simple as I can make it, just make sure that, you know, if it's editing, if it's adding captions, if it's doing those types of things, that's de minimis. It's a technical use of the AI, right? If it is appreciable, it's actually creating the art with you. And there's a really, I'll send it on the links. The Copyright Office has a really good video. I'm sorry, it's like probably like an hour and a half, but it talks through like different examples of using AI and when it's appreciable.
So when you wake up at 3 a.m., those are the videos that you watch, the hour and a half?
I plead the fifth. I'm not.
Okay.
But yeah.
Speaking of, okay, let's shift to the word fair use here. So this is for both of you. You say fair use is a legal doctrine that allows limited use of copyright work without permission. It's evaluated case by case on 4 factors. Courts are currently split on whether training AI on copyrighted works qualifies as fair use. Some courts have said yes, it's transformative. Others have said no. This is the most active legal battleground in AI and IP right now. If I'm an artist and I find out my work was used to train an AI model, what is my actual legal position today? And I'm just going to back that up with, what else can I do? You know, not just my legal position, but what can I do in case these cases come down in favor of people that have been trained on, you know, what should I be preparing? You know,
let me start a little bit on the art history angle. So most artists, musicians, creatives, how did they start out? They started out by copying and mimicking and learning from prior successful creatives, right? Like my father is a painter. He started drawing comic books as a kid and started training his hand and started training his process, right? So a lot of musicians start by playing covers. It is inevitable that your work will be influenced by those giants that were before you, right? But at what point, is it inspiration? What point is it fair use? And that's where you listen to some musicians and they say, well, there's only so many chords you can play, and there's so many songs, and they can kind of show you what songs sound very similar and have very similar chords and similar compositions. And so it's also, it can get kind of murky when it comes to what's inspiration, what's for use, how much is too much.
But here, we're not talking about here individual to individual here, or people learning as children. We're talking about AI companies wholesale scraping massive databases of people's work from the metadata and images. So I want to address that, not the training.
But also, so like, at what point is AI becoming a crutch rather than a tool? So, for example, right, for like historically, there have been tools that have helped creatives become better at their craft. And other creatives have criticized them for like, oh, well, they shouldn't be using, a projector to sketch. They should do it freehand. But it sped up the process for a lot of visual artists. Or even
camera obscura, since
right, like there's certain things. Yeah. So like, AI is a tool, but it's a tool like we've never seen before, and it's going to rely a lot on what society going to say at what level, should it or should it not.
But I don't think that's the question. I think the question is, how do we address the issue of AI companies claiming fair use, in scraping our information wholesale?
Can I interject?
That's going to be tough. I'll let Somara handle it, because there has to be a line drawn somewhere, right?
So in the AI law and regulation output that I created, I formatted it, right, using Claude. I also had to double check, because AI, who uses AI here in the room? Does anybody use it? Okay. Pretty much everybody. All hands
go up.
Okay.
Yeah.
So when you use it, as people who are familiar with the software, you know that it hallucinates, right? It may give you incorrect information. So when I looked over it, I made sure to double check everything that was on there. And right now, does anyone know about the Anthropic case? Does anyone use Claude?
Yes. Yeah.
You do? Okay. I'm not pointing anyone. Someone does. Okay. So Claude had a case. It's by Anthropic. It was Bart's versus Anthropic, right? That case, actually, they trained exactly what you're talking about. They trained their data on all of this material, mostly written material from a bunch of authors. And some of it was licensed, as in they bought the books. Some of it they got off of these forums that are known, like OpenSea and things like that, where you can get a bunch of free pirated material. I'm going to date myself. Does anyone know what LimeWire is?
Yes.
Okay. Yeah. So LimeWire, Pirate Bay, all these places where you can get all this music that was pirated. Okay. So they got it from these two places, Bart's versus Anthropic. The court found, at least on the work that was purchased, that's fair use. If you purchased a book and then you put it into your data, your AI training, you're fine. If you, now this is where it stinks. I'm not going to.
Okay, yeah.
If you
give us the real. Yeah.
I'm really working. I used to litigate, so I curse, and I'm trying not to curse as well.
That's okay. We have a bleeper.
Oh, you do?
Yeah,
okay, well then, no, I'm kidding.
Go ahead, curse, and I'll go ahead. Try it. Do a little cursing.
You're gonna get me in trouble.
Bleep.
That's not happening.
Bleep. No. Oh, I'm sorry.
It's a Dimitry.
So I say the word and then he does it. Okay, so moving on from there. Unfortunately, they settled the case, Anthropic, before we got to the question of, if you take work that is not licensed from those places, is it fair use?
Can you just give us a very basic primer on the law? If a case is settled, what does that mean? Why are you say unfortunately?
Oh, because
it no longer it doesn't. There's no precedent.
It does. Yes, it doesn't get a court decision. Okay. Precedent's a big fancy legal word for saying like this is our standard for this particular case, right? So there's nothing that says, hey, there's guidance being like, yes, it is, or no, it's not. All we have right now is a couple of executive orders from this current administration, and we have a proposed bill from Senator Blackburn that says outright, which was surprising to me because this is very separate. I'm sorry, I get excited about this stuff, but it's very separate from what the administration wants, which says that fair use is not blanket, doesn't happen if you don't have a license. It follows what the Copyright Law Office is saying as far as guidance is concerned. So we're at a place where I can't tell you, yes, we have a definite answer because we don't have any guiding legal principles right now.
Can I say something about what you shared and you gave me as this addendum, you know,
Yeah.
our sort of 7th or 6th, whatever, I forget how many we have now, reference guides, that is a PDF linked in our resource guides. One of the things that comes out of that, and I'll just summarize it this way, federal government, very little movement. States are filling in the gaps as they can. And some laws, like some actions by the federal government, are trying to prevent the states from
Because
doing
of the
that.
Supremacy Clause.
Supremacy clause.
Yes.
Okay.
So federal law.
It had to be the word supremacy.
I know,
knew
right?
it.
Exactly.
I knew
I'm
it was.
sorry.
It's always. So when you say that it's unsettled, there's
Yeah.
different levels. You know, at least in this country. You know,
Right.
with that, and so there may be a chance, even with the fair use situation, from what I understand of your document,
Yes.
that it may be retroactively like liability based on a decision that says, no, you could not have used this data for training all of your models, and you must pay or
Potentially.
potentially, right?
Potentially,
That could be
yeah.
the best outcome ever
I
for
mean,
artists, right?
I never thought I'd be happy about a bill like this,
Mhm.
but it's a blanket bill. It involves. Does anyone know what the No Fakes Act is?
No, but it's in that document. I
Yes.
remember. I mean, I remember reading like it was like a big deal.
Right.
Can you describe it?
Yes, of course. So I think everybody on here uses social media, Instagram, TikTok, all of these, right? Yes, maybe. Have you seen any people talk about the fact that especially a lot of influencers are saying that their likeness, their voice, and their face-
Wait. Term number 5, right of publicity. Okay. You say the right of publicity is a state level right, not federal, that protects your name, voice, and likeness from unauthorized commercial use. Florida has one, but it's not the same in every state, and the AI voice cloning situation that Benedict Cork experienced may or may not be covered depending on how the law is interpreted. So this is for Florida-based artists specifically. What does our state's rights of publicity actually protect, and what does it mean? So weave that into your answer, and this is important because they didn't just finish his song and publish it. They cloned his voice. That's why people were thinking he had finished the album. They cloned his voice.
But it doesn't take very much to clone a voice, which is what makes AI so dangerous and tricky, right?
Yeah.
Like they're
Apparently less than 15 seconds
Yeah,
of voice
yeah,
could
it
be
doesn't take very much.
used to clone a
But
voice.
that's
yeah.
why, again, right now, federally, the No Fakes Act would be a federal level. Remember, we talked about. I didn't explain the supremacy.
Yeah, they're different level.
The
Yeah.
supremacy clause says that if there's a conflicting state or local law that conflicts with federal law wins. That's
the
supremacy,
supreme law, of the
right?
land.
Exactly. So right now we don't have law. What we have are executive orders and proposed bills
Mhm.
on the federal level.
Mhm.
What we do have is certain states that have laws, like Tennessee, California. Florida is very limited. So there's really not much that you can do with that.
But we run into a bigger problem internationally too, because remember, like even if the federal government were to say, "This is the supreme law of the land. This is going to be the guiding," other countries don't care, right? So we run into the international issues where sometimes creative's work that's being taken is not being taken by domestic actors, right?
Right.
So then we run into
Internationally, it's
international
better
treaty.
though. Like the EU, even
WIPO,
Asia, like all of those places. I had on the original PDF. It also had international laws too,
Yeah.
but it was going to be too much.
Yeah.
So I stuck with the US.
But the EU is a little bit more
But they're better-
advanced when it deals with it's willing to. Some places are willing to deal with.
That's what
AI.
I'm saying. So
Yeah.
there are things that, just going back to the Supremacy Clause and No Fakes Act. The No Fakes Act would be a federal law that would keep people and have actual civil consequences, meaning fines, certain other things, penalties that would keep people from being able to use your voice, your face, your likeness generally without your permission, right? We don't have, like you said, a right. That's called the right of publicity, right? If you are who you are is sort of your fingerprint. It's your ID for you. So when you go and someone else uses it, you have to go by state. So if I wanted to go ahead and file, and some states have stronger protections than others. Like if I wanted to do now and deal with a voice, image, and likeness case, I would set up my business in Tennessee. Because Tennessee is the only one that has, with their Elvis Act, which I think is great, it's called the Elvis Act. But they have protections and they have consequences that are both criminal and civil, right? So when I talk to my clients, I'm like, well, if you're making your art, where do you want to strategically think about putting your business? Because you want to be in a place where you're best positioned to protect yourself. Because right now we don't have federal cases. So with right of publicity, it just basically is a protection that you have to make sure that if you are having your voice, your likeness, your even signature, right, that it's going to be authorized by you. But right now the problem is that it's a patchwork problem. So if somebody on the internet does it on Instagram, there's really not much that I can do unless I file a case for appropriation of my likeness. We're saying if my voice is so distinct, I'm basically, I am my signature, right? Then I'm able to go ahead and file a case. There was Bette Midler versus Ford. She had that where they actually had the right to use her song. This advertising agency asked if they could then have her sing the song with her voice, right? She was like, no, we're not going to do it. We're not interested, right? She tried to do it under copyright. She couldn't do it, right? Because your voice is not copyrightable. But she did something called an appropriation claim. So they appropriated her rights. So right now, technically, you could do that, but you would still have to do that in the states where it applies. And also, your state might not have those kind of protections, right? So let's say you do it. California is actually a really good state, but maybe Alaska. I don't think Alaska has it.
I think Tennessee, Colorado was mentioned, but
yeah, Tennessee, Colorado, New York,
and California.
California are the
better ones
right now.
Okay,
yeah,
interesting.
So you just have to apply it. You have to think strategically about where do you want to protect yourself. But right now, there's nothing that you can do legally without having to file suit right now.
So there's also no coincidence that Tennessee and California think this way because of the industries that they have.
Entertainment,
and New York too.
Yeah, music and film.
So they are these strongholds of music and film and entertainment and production that the states that don't. The legal system responds to the squeaky wheel is going to get the grease, right? So if constituents are coming to the legislature and saying this is a big problem for us and they're a huge voting block, they're going to address it, right? So
But throwing in this, because now it just kind of feels hopeless, right? Does anyone feel like there's really nothing that you can do? A little bit? Okay. So I want, again, why I did the workshops with artists is because I'm like, you kind of have to wait for the law to settle. And you don't want to wait for, because the law will handle the problem after the harm has been done. So after you've been assaulted or after somebody's stolen from you, then now you have a right. You have a case, you have standing, right?
It's the same with AI.
You don't want to, but what you can do, and I've been asking, and I think I talked with you about this, but the last time that we had it, there are things that you can do to what we call poison pill your files so that they're not scrapable. So for visual artists, I think it's University of Chicago did Nightshade Project. Does anyone know what that is? The Nightshade Project, what they do is, you are now going to have to be technical people. I know you don't want to, but it's going to be something that you need to know about your metadata. You need to know what's in your files. So if you use Nightshade, what it does is the AI will read this, they're scraping your data, and you have a picture of a cat, for instance, right? And then it's going to read it as it's a picture. When you put it through Nightshade, it's going to read it as this is a dog file. Right? So then when it tries to scrape it, it's getting the wrong information and it can't scrape it. So for visual artists,
so it's creating like confusing shrapnel, linguistic shrapnel.
Exactly. It's like little landmines. Exactly.
Yeah,
so for visual artists, that's great. You can use Nightshade. There are other ones. I was going to give him a list. I'll probably make that list happen.
We can update the guide.
Absolutely. But then for music, it's a little more difficult. So the University of Chicago saw that and they're doing Glaze. And there's some other ones too. So are any Reddit users here? No? Yes, maybe? On Reddit, this is what I follow, and it's very helpful because these are people who are actually on the ground doing it. It's AI Wars. A lot of information can be found there because that's fellow artists who are doing the same things that you do. So when I talk to artists, I'm like, the first thing that you want to do is see how you can avoid the data scraping as much as you can, because you don't want to be you can't stop AI completely, but you can make it more difficult to take your art. So maybe don't put the full version of your song up, put the worst version of your song up. You know what I mean? Put things that will make it easier for you to still share with your audience. Share the process maybe. Don't share the actual finalized art. And make sure to register a copyright. I know that sounds dumb, but registering your copyright allows you to move forward with federal litigation because what they're doing is creating an unauthorized derivative work. So as an artist, you have certain copyrights, right? And those copyrights allow you to make sure that your work is used how you want to use it. Right? You can authorize people not to use it or to use it however you want. And one of those rights is to create derivative works. So let's say I find your art, I really like it, I want to put it on a tote bag, right? I have to ask you, right? But when you register your copyright and somebody does that, obviously the first thing you're going to do is do a DMCA takedown notice. Does anyone know what those are? Yeah.
Digital Millennial
Copyright Act.
Copyright Act.
Yes.
Yeah.
So what it does is you go to the platform that's hosting it and you say, hey, this is an unauthorized use of my copyright. I want you to take it down. That's usually the first step. But the other thing that you want to do is if you want to keep going with your case or you feel like, you know, your DMCA request was denied, you can file suit. And there's 2 ways to file suit. You don't have to just litigate through federal court. There is a copyright royalty board, which was created a couple years ago, and it allows you to do small claims. And you can actually represent yourself. So
that sounds like good news for change. Yeah.
The only problem is that the other party has to agree to show up in court. They're not forced to, like when you do with litigation. But it does leave a trail that if they decided that they didn't want to do that, that's helpful for your case if you do move to litigation.
It might be good to mention a detail that became important with copyright a few years ago. Now, I don't think it was related to AI, but that merely having a copyright for creating something automatically, meaning I don't even know what that's called, just like a natural copyright. I don't know.
Oh, if it's fixed, which means that it's original, right?
Yeah,
I can't write Gone with the Wind today and say it's mine, even if I
Yeah.
wrote it down by hand. So if it's original and it's fixed in a tangible medium of expression, meaning
Okay.
that it's physically accessible to your audience somehow, either auditorily or visually or whatever it is, then you have a copyright already without
Yeah.
doing anything else. The registration of your copyright allows you to protect it in court.
And that's a
the
new
difference.
thing. That changed. It used to be you could litigate.
You could before, but now you have to actually
Now
get the
you have
registration.
to. So the registration is important.
Yes.
Yeah, because
So-
you can't actually act. So
Unless
for
you have
example, you
registration.
can't do a DMCA.
You can, though.
You can?
You can.
Okay, correct me,
Because the
please.
DMCA will allow you to, if you say that it's original and it's yours,
Yeah.
then they allow you under the DMCA to take it down.
Okay.
But if you lose your DMCA, right, like your appeal or your request, and then you want to take it to court, then that's when you need that registration. And registration takes about a year.
Okay.
No,
Oh, it's a year now? That's like a trademark. It's
Trademarks
not-
are a year and a half, 2 years now.
Oh, wow.
Yeah.
How things are moving slowly.
Go
Yeah.
ahead.
where I've seen artists, for example, have some tricky situations with clients is what happens when the client commissions an original work. Who owns that work's promotional value? So it's very easy to say, okay, thank you, collector. You paid $50,000 for a sculpture. But do I, as the artist, retain the right to mass produce miniature versions in a limited series? The one thing is a lot of creatives just maybe they don't think about it or they think it's not going to be an issue, but it's very valuable to think about, okay, am I selling you this one piece or am I selling you also the rights with this piece? And where there's value for a lot of the creatives I've worked with is they've solved the problem before it happens, where they have had clients sign that the client does not own the right to reproduce, does not own the creative expression, just owns a singular
The object. Yeah. Or the
object,
thing.
right?
Yeah,
Which
yeah,
protects them in the
artifact.
future because they're like, before I produced the product, before I sold it, I made it very clear.
So
to
this
the
has to be
purchaser.
stipulated in the contract. It's not automatic.
If it's not clear and documented, it gets into this space of like it could be litigated, right? It could be very costly. That's why I say like sometimes the best thing to do is poison pill. Sometimes the best thing to do is put it in writing and get the agreement. Get the client to sign. Get
But
the client to.
I want to bring
agree.
this back to AI. So let's
Yeah.
take your example. I sell a piece. I didn't have that contract clause. The client reverse engineers it using AI and then makes copies of my work instead of me making copies of my work. Is that a potential scenario you'd want to avoid by having the proper contract?
But see, the contracts are this magical place where you can put so many things in that contract that may or may not even be law yet, but maybe your agreement between the different parties. And that's where I tell the creatives is you have a lot of power in contracting. And a lot of creatives look at contracts and, get chills. Contract should be your friend.
Wait, so you've just created a little wormhole in my head. So you're saying that contracts, because it's an agreement between parties, you can kind of invent your own law, what is that? What is it exactly that you're saying?
Don't think of it of your own law. Think of it an agreement between multiple parties, and it may be an agreement between you and the buyer or the collector or the investor. But what happens is ambiguity can ultimately lead to litigation, can be very costly.
Mhm.
So people can enter into all sorts of agreements, right? Now, whether the courts are going to uphold it or whether the law is going to say that's enforceable, but at least if the law is unsettled in certain areas, why not make the attempt to put it in a contract to say, okay, this may be unsettled, but this was our agreement. And it's a lot easier to enforce something that was signed and notarized and an agreement between parties than to say, well, Dimitry and I agreed to it over a cafe, over a cappuccino. We'll prove it, right? But when you have, also with a lot of creatives, they want to start thinking about documenting things via written communications, because then you have a track record of it. You have something to say, this was what we agreed upon. Where I see a lot of creatives fall into some, pain and potential cost is that they were communicating with a client and the client had one vision and the creative has another vision. And then it's also not all of the middle kind of jive well. That's why the contracts give you a great opportunity to deal with clients in a way that they understand what your expectations are, and to make sure that naturally in conversation, there's some things that you're just not going to talk about. And you're going to say, well, that's how I always do things. Well, if you didn't bring it up to the client, right, there could be an ambiguity there that causes some issues. But having really solid contractual agreements, of expectations of clients and expectations of the creative really creates a much smoother experience. And I've noticed that the creatives that I've worked with that it doesn't have to be a complicated contract, but that really take to heart, these are the important things that I want to protect, can get that out there. And, it rarely will cost them the deal, but it creates almost a safety net for them.
Do you want anything to add to that, Somara?
I think when it comes to selling art, and also you have to look at the practicalities of artists, at least the ones that I've worked with. A lot of times they don't understand how to create the contract, so making a contract can be difficult for them without a lawyer. So there's an issue of what's perfectly done and what you can have so that you're protected. So what I tell people, if you don't have an attorney, is to say that I'm selling you the artwork, but I'm keeping and retaining all of my copyrights and moral rights. A simple sentence like that in an email is usually sufficient enough to protect you. And if that person then buys the art from you and you have an invoice, that's the acceptance of your terms.
Yeah, because they didn't respond saying, I disagree with that. No, I want to negotiate something else. So sometimes it's as simple as sending an email and saying, my understanding of this artistic endeavor that we're engaging in is this, and this, and if the other party doesn't respond and proceeds.
But right? I agree with Andrej that you want ambiguity is bad for artists. It's bad for anybody who's trying to sell their work or to deal with their clients. I just think you have to look at the practicality of the thing, because if you're an artist who can't afford an attorney, or if you need a free attorney, because I had a whole list of that before too, and it took them 6 months to get a free attorney, either through they have a program, they have legal clinics, FIU has legal clinics, but none of these things actually get the artists to do at that real time when they have the issue to handle it. So I'm like, send an email, be clear about what you are providing them, which is just the physical art that they have and they can resell. But if you want a right to license your work, if it wants to be put in a movie, these are things that you want to be clear on. Now, pushing back because you're right about ambiguity. If you just sell the work to the client and you don't have a contract, by default, you still own the copyrights.
You do.
By default, U.S. law says you still own the copyright, even if they pay you. I tell artists all the time who are musicians, if you have a producer and you pay them for a beat, you don't own the song. You don't own the beat. The producer still does. They have the right to reproduce it. They have the right to license it. They have all these other rights. But just having that simple email that says, I'm selling you just the work. I'm retaining all of my copyrights. And then it's like, you can even say, if you don't respond, I throw that in there. And that means that you've accepted. Just making it very clear.
Fun, though. Let's say, for example, you've got a creative that is 60, 70 years old, 80 years old, right? Their productive life may not be so many more years, but putting into contract some very creative notions of, if you as a buyer are to ever sell this piece to anybody else, that first right of refusal is given to our family. Now, why is that important? Because maybe that art, and what the value is.
Can you explain what first right of refusal
So, okay, so first right of refusal is, for example, we've done a transaction, right? And we both freely entered into this transaction. But if for whatever reason you were to want to alienate whatever you own, like let's say I'm a sculpture artist and I created this beautiful sculpture, and I say, you know what, I don't know how much longer I'll be able to create. I've got extreme arthritis. I maybe only have 10 or 20. I will sell you my piece for $100,000. But what I want is that if you were to ever sell it, that the first person that gets the opportunity to buy it is one of my descendants, like whoever's left, right? My children. I may say my children. And that creates an interesting caveat, because I've sold you this piece. You can transfer it to whoever else in your family you want to transfer it to. You can give it on loan to a museum. But if you were to ever sell it, that you give somebody in my family the right to purchase it, right?
But it could be at fair market value, I would assume.
It could be, right? And let's say you say, well, that you have to sell it for this certain amount. That is where you could end up in litigation, and it'd be difficult to, right? That piece may now be worth $50 million. And I said in the contract, well, my family member can buy it back. And that
I want to bring it back to how contracts can work to either enhance or protect you, enhance your AI position or protect you, So maybe you're really pro AI. You want to use AI to replicate your work or derivatives of it in some way, So how can we bring this back to AI in terms of the contracts? Because you obviously know a lot about contracts.
So here's the thing with and I think that's something we both kind of mentioned, is that creatives should feel comfortable using AI to draft their own contracts.
Okay.
But there's always going to be missing legal concepts that you're only going to get from attorneys. Because what happens is you don't know what you don't know, and the AI is only as good as the input.
And it's kind of lazy, respectfully.
It really is.
It'll give you the shortest, most efficient version of the contract that's not going to necessarily be
as
what
extensive.
You need. Yeah.
But it's also
but it's also getting better all the time, right?
Okay, AI.
And I will say, in doing research for this, I went into an Instagram rabbit hole just by doing a search, and suddenly I was getting all of these ads for legal AI variations. Some of them were addressed to attorneys, like make your practice better with this AI tool, and others were addressed to artists or people that need AI, not necessarily artists.
The difference is the data set.
The data set.
Okay, so there's I think Simply Legal, there's Spellbook AI. I've gotten all of them.
But this is all moving so fast. You sound like you've got it all covered. But how long do you think it'll take before there's I am your AI attorney, and I can draft a contract with all the clauses?
There's a New York law that's pending that's for lawyers specifically and professionals that doesn't allow AI to do legal work for you.
Oh, so you're using a law
to protect
the lawyers.
Yeah.
Okay,
but
this is gonna be the last little exchange before we go to questions, because we're getting close.
And not to interrupt, because I do my whole job, entertainment business wise, is contracts. So as far as protecting yourself, I always tell clients, because I charge cheaper for this, I'm like, use AI to create your initial contract. Find an attorney to review it for you, because an attorney is going to be able to see the loopholes that you missed. Like, you wouldn't try to create this building and be like, hey, AI, can you create a blueprint for me, right? It's going to miss some walls. It just is. So then you have somebody who's able to review it and fill in those gaps for you.
We have curators in the room that may know of artists that are using contracts as a form of art. It sounds like AI contracts are going to be a thing.
They already are.
They already are, I'm sure, right?
There's smart contracts too. So I had people, when the NFT craze was happening, I had a lot of artists who were doing NFTs. I was on all of these places. And I remember with the smart contracts, which was very helpful, it automatically gave you commissions if anybody resold your art, which was fantastic. But
until someone sells your art to a country that is on a terror list. And then suddenly you're given a contribution because know your customer rules suddenly, and maybe it's a financial instrument and not a work of art. That's why I did not do NFTs.
That you could do, if you sold it and you're still getting a commission, you could say that I have no liability for the next person.
So that's still a clause that only a lawyer would tell you about.
Exactly. So that's why you want to just use it. I mean, they're very helpful. They have a lot of information. They'll have the basics for you. But I really encourage you to find an attorney to review it for you. If you're at FIU, because this is FIU's, and I'm a big fan of FIU, even though I went to UF.
Yeah, we weren't going to mention that.
I got into FIU College of Law. I just didn't go, and I regret that.
That's
I
even
really
worse.
do. I regret it. It was a good school. It still is.
We're glad you're with us now.
Thank you. But yeah, just go through it. Have an attorney look over it. If you can't get an attorney to look over it, try to do free legal services. Do a legal clinic. FIU has a great one, and they will go over the contract for you. There's volunteer lawyers for the arts. I'm going to shout out them again. Attorneys like myself, we do it for free. I haven't gone, but I tell other people to go to volunteer lawyers for the arts. And I hope I can start doing that again probably this year to go ahead and do that. You have more capacity and you have agency. And I feel like AI, a lot of times it's depressing to talk about. And I don't like doing these panels sometimes because it feels like you have a lack of agency and there's nothing you can do. And that's furthest from the truth. Use it to help you get your art to other people, but also have somebody help you review it, right? Just have it, however you get the help,
Keep that human connection.
Yes, exactly. Because again, there are people who are utilizing AI, and those programs, you still have to have somebody overview it and double check it and go over it. So I agree with what Andrej said, but I'm also saying, don't be afraid to use AI for certain things, but know the law, because the law is going to help you protect yourself, and it's going to help you protect your people. You want to make sure that people who are buying your art are actually buying your art and not somebody else that was created by AI. Okay, that's it. I'm off my soapbox.
I've always had a question about how branding can actually work in this case, because you can have a trademark. Let's say you trademark your name, your signature as an artist. You know, not just because apparently you can't protect your style. That the AIs can steal your style, which is what most artists think of when they think of their own work. So how could you use into other tools to kind of triangulate against?
I'm glad you brought that up. So I'm trying to think of the famous photo site. I think, is it
Pixabay?
No, not
Flickr.
Pixabay.
Unsplash?
No, it's they make the photos, and then you can license it from them. And I'm drawing a complete blank right now. But they have their trademarks on, like their watermarks on there. And then AI took one of their pictures and then recreated it and then reused their watermark. Now you have a trademark case, right? Yeah. So using your signature on your art is helpful. Something that identifies you. And a lot of times what we're finding success with cases is not copyright, because copyright right now is very difficult, but trademark cases are helpful. I don't know if you know about the Google and the Meta case that happened in California, where they got a $6 million judgment against them. It wasn't because it was based off of copyright. It was a product liability case saying the software itself is addictive and it's harmful and it's causing damage. So you want to look, especially if you're an artist, look at trademark. Look at your signatures, look at imposing something that's going to be able to have you have a better chance of fighting against even if it's your, let's say it's a self-portrait, right? Then you can try to do with the appropriation. You can go with, name, image, and likeness cases. So there's lots of things that you can do, but the first thing that I suggest, and I highly suggest, is do your best to make the art hard to scrape. So look at your files. Make sure that when you're uploading things, there are things and layers that are going to keep it or make it more difficult for the elements.
But I have a question about that with regard to the poison pilling, because these AI, algorithms or the LLM models and the ones that work with images specifically.
I think I know where you're going. You're saying it's adaptive and maybe what's happening.
Well, no, that just at the basics, originally, the reason that AI knew how to create a banana for you, if you asked for a banana, was that all of the images were tagged as bananas in the alt text, for compliance with the ADA law. So if you poison pill your banana and make the AI think that it's a cat, are you also then confounding the ADA rules, so that now you'd be stuck with an ADA lawsuit instead of an AI infringement?
That's a good question. I will say for the University of Chicago one, no. I can't speak for the other ones, but that's going to make me go and look more into it. I would say that right now, the law has not settled. So since it's a gray area, do it until it becomes a problem.
Great.
Right now, I would say.
So we'll take a deep breath on that and ask for questions. Diego, I think we have a mic somewhere.
That's
I don't
a really
know.
good question.
Yeah?
That's the hard ones.
I always try to stump you.
You
but
do.
Yeah.
You do.
I'm glad I finally got you on that.
You get me every time. I'm going to start.
A computer can never be held accountable, therefore a computer must never make a management decision, right? That quote is as old as I am. My question to you is regarding kind of the elephant in the room, right? What people are doing and what's the liability of the companies that are behind this, to produce or reap the benefits from some artists, to create something. Don't you think that it needs to be some type of fingerprinting? An example will be deep fakes or many other things that are being put out there that are using people's images, are using people's works. Don't you think that it needs to be some type of consortium for AI creators that put some type of fingerprint? That's the word, a fingerprint for the content that is created, so other people know where that is coming from, and then there is not such a divisive appreciation for the work that is being used.
And do you think that in AI wars, people fingerprint and unfingerprint? Like, are there, how technical does it get? I'm assuming
It's a bunch
pretty technical.
of like computer science people.
Mhm.
So it's pretty technical.
Mm.
But regarding your question, which is your point and your question, which is, they're both good. The problem still remains the same, that we don't have settled law. So even if we have fingerprinting, I could still technically right now, because we don't have an actual answer on whether data scraping of everything on the internet is fair use or not. I can see that it's data scraped. I can have your fingerprint, but that doesn't necessarily mean that I'm going to have any liability against you. Unless you have maybe, again, a contract, which is going to be the strongest thing, where that consortium of artists has something that says on their terms of use, you are not allowed to data scrape our art. So if you did that as a collective and you had terms of use that said that, now you have something to deal with, because now you have a breach of contract. Because by using your website, they agree to your contract, and now they violated it. Does that make sense?
And sorry.
Yeah, no, don't apologize.
What about utilizing other services like social media, where they have agreements that say as long as you upload the stuff to their servers, they own the copyright of what you're putting?
Well, usually with social media platforms, they don't say that they own the copyright. And that has to do a lot with the fact that they don't want to have the liability for that content.
Like Section 208?
It's 230.
207?
Yeah.
Also, like TikTok, for example, puts now, with AI generated content, if you look at the bottom left, it's very small, it's almost unnoticeable. It says created with AI. Because sometimes you'll see something and you're like, is this really real? Is this even?
Yeah.
And sometimes you're like, is it? But some of the platforms are starting to be more proactive about marketing because they don't want to mislead their community.
It's
also don't
interesting
wanna
though,
get
because
sued.
I've noticed this on Instagram. I'm not on TikTok at all, but what I've noticed is it'll ask you, the disclosure will be, this is AI that looks real.
Yeah.
That could be confused for reality. But if you made, like I saw one recently, which was a cat lying in a gelato bed, like a gelato tray, and someone scoops the stomach of the cat, just the fur, it looked perfectly legitimate. I was like, oh, that's so weird. And then they plop it into an ice cream cone, and then the ball of fur turns into a kitten, and it's like, oh, AI, of course, so. But that could be more creative. That could be an artist's work, right? So that doesn't require disclosure because it's obviously imagination, right?
But when it's not, it could be misleading. It could cause panic.
Yeah.
Well, okay, so I want you to repeat the question one more time, because I think we've lost the
You lost the plot, yeah.
Yeah.
I mean, I agree with what you're saying, that you can have some type of contract where you're putting stuff on your website
But you're
that's
saying what
forever
you're saying.
used, but whenever you're trying to promote yourself and you're putting this, even if you're putting it on an open call,
Yeah.
that later on they're using those images, you're agreed to for them to use your images to promote whatever services they have, then you feel like you're losing control and they're using the images in a different kind of manner.
Yeah.
And anybody can just grab those and repurpose them for something else because it's fair use. I found it on the internet and I don't even know who they are.
It's not settled law that it's fair use. You decide to share and promote your work, but also remember that if you get off of Instagram, if there's a mass exodus, Instagram is probably going to change its policies. They need you to continue to have people on their platform. They're not generating anything on their own. So you have more power, again, than you think. So just think about that when you're going ahead and using it. But as far as your fingerprint idea, I think it's great. We just don't have settled law. And until we have settled law, we're still going to be in this area where we have to kind of figure out how to work in this murky gray area. Does that answer your question? Okay. It was a great question.
Anyone else? Terry,
That was so helpful. And
maybe we have a mic. I don't know.
as
Yeah.
you were speaking, I was curious if there are other specifics for the terms of use that you would recommend having artists put on the website, or if there's anything in the metadata that you could add. I think beforehand, I was thinking about what you were speaking earlier in the conversation about Tennessee and maybe the advantages of an artist to like start register in those states. Like if you're for artists in Florida, if you're gonna start from scratch, would you do an LLC? Would you do it in Florida? Is there another state that you'd recommend? Because I know for some businesses they incorporate in Delaware for different advantages.
Yeah.
So for an artist, what would you recommend?
Well, we're going to give you, at least I'll speak the disclaimer. We're not your attorneys. So this is educational information, right? But that's a great question. You can have, this is where I'm telling you where Andrej is like the power of the contract is very important. You can have a business registered in Florida. But there's something called governing law, which everyone passes over, but it's probably one of the more key aspects of your contract. It says when there's a dispute, where are we going to litigate this? Where are we going to deal with it? And maybe you don't even litigate. Maybe you do arbitration and mediation, right? Which means that you get out of court completely. It's more expensive on the front end, but it's less of a headache and completely. But you can put governing law, knowing that, because now you have what laws or what states are more artist friendly when it comes to AI. You can put my business is in Florida, your business is in Florida, but our governing law is Tennessee, right?
Contractually. Right?
So the contract says that if we have a dispute, even though I'm a Florida business, we're going to have to go to Tennessee. Now, that does mean that you have to get a Tennessee attorney. Because if you're going to have a business, you can't represent yourself. Your business is considered a separate entity. So even if you own the business, your LLC is completely different, right? So you're going to have to get an attorney for that. But knowing that Tennessee is favorable and they do have free lawyers through the Bar Association or other programs or services that could be helpful to you, you can litigate it in Tennessee. Or you can do arbitration, which means that you don't go to court. You can appear by video. That's what I put in all mine. And I'm like, okay, well, the law is going to be, Tennessee law is going to govern. So now I can stay in Florida. I can appear by video, obviously wear a suit jacket, but pajama pants on the bottom, and then do what you have to do in court. And then your attorneys can go ahead and do that as long as they either are pro hoc vice, which means that they have a temporary right to be an attorney in that state, and that means they have to have another attorney there who's from Illinois from Tennessee and is barred in Tennessee. Then there are other things that you can do maneuvering with your contract to help you. Does that answer your question?
Yeah, I think that's an interesting point.
Yeah, so look at governing law. You can still register here. Just pick what state is going to be most beneficial for you if there is a dispute.
And a lot of creatives will think about like creating certain fail safes, like that the first step is going to be arbitration instead of litigation, and that you're contractually binding all the parties involved, which means that we're not going to take it to court. If it gets to court and somebody files in court, they'll go back to the contract and say, Judge, we agreed contractually to go to arbitration first, and then the judge will gladly punt it
They
to
don't want your
arbitration.
case, yeah.
They honestly, they all courts have bottlenecks, so they want to get rid of cases, either have them settle or have them go to other means of mediation, arbitration.
Yeah, so start with non-binding mediation, which means that if you and I come to an agreement and I decide to screw you over, there's really nothing that you can do, right? That's mediation. But you can choose to then either do, usually you don't do both. Usually you'll do, even though I've seen cases that do that, you'll do arbitration and choose not going to court, because if you do it to court, you have your local level court, which is usually your district court, then you have to appeal, right? Then you have your state Supreme Court, and then after the state Supreme Court,
So it
you
could be endless.
make your writ of certiorari, and your writ of certiorari goes to the Supreme Court, and the Supreme Court has to decide if they're going to take your case. And then if they don't take your case, they either say, no, we're good, thank you, or they do take your case on, and now you have to deal with the Supreme Court case. If you do arbitration, usually arbitration takes like a year. It is more expensive up front, but
So what are we talking about in terms of money? When you say upfront, why is it upfront and why is it more expensive?
no, I mean, as far as like money is concerned, because with litigation, like let's say you file a case, the complaint's going to cost you maybe $350, $400.
Okay. Yeah.
And then if you're a defendant, so the person that's being sued, then you have to respond. Now, if you have a litigator, depending on how much they charge, I've seen litigators who start at 3,000 if they're nice, 5,000 is normal, and then you go on and add fees from there. But there are litigators who will take on your case pro bono because it is a case that's going to put them on, as far as like give their firm more national attention, because this is a case that's going to be big for them if they win or if they lose.
Okay, so
right?
you help their brand.
Exactly.
Yeah. Okay.
So they look at it more as a PR situation for them. It doesn't happen often, but that's something that does happen.
Interesting.
So arbitration, it'll cost you probably 10,000 or 8,000, but your case is done in a year. There's something called discovery. Does everyone know what that is? So basically, you go, when I file my case against you and you do an answer, you respond, I have a chance to go ahead and get evidence from you. So I'll ask you for documents, I'll have you answer questions. That usually takes the longest amount of time, is the discovery period. And then after that, then you'll go to court, which depending on your judge, and I've had judges that really want to get their cases off the docket, and I have judges that were like, I'm taking a vacation, I'll see you next year, right? So it could be, your case could last several years. Even I used to do product liability cases, it was a decade.
Wow.
Right?
Yeah.
So and that was against hospitals. So when you have arbitration, you know you have a set amount of time. You don't have to go to the arbitration. I always say that I can appear by video conference, and there's 2 major mediation arbitration places in the United States. They are American Arbitration Association and JAMS. So most people are going to use one of those 2. There are international ones as well. So if you're an artist, most artists I know deal with people from different countries all the time. So then you can have international arbitration too. So it just makes things easier. And you can try to do expedited, and if you do expedited, it tends to be cheaper as well. So just think about those things when you're making your contracts, and make the contract work for you in the best way possible. This is a strategic decision that you get to make as an artist, and this is where you have the most control.
And once you have a good contract, you can use it over and over again.
Yeah.
With very little modification. So it's actually cost effective. Start with an AI, start with a framework, go to an attorney for a very limited amount of time, get them to fill in any of the gaps, but then you can use it almost in every client situation, unless that client dramatically is different, and then you just have some minor adjustments to it. So it really empowers you to have that first layer of protection that can save you a lot of money.
I have a question that relates to that, since we've talked so much about contracts. And does anybody else have a question before I? No? Yeah.
We appreciate your time.
Yeah,
I know
yeah.
that this is hard to talk about AI. And like I said, it made me extremely depressed to have to talk about this. But I do think it's important to let people know that you do have a lot more power than you think. And knowing the basics of the law will help you figure out how to protect yourself. The reason that AI has proliferated so much is because there's a lot of ignorance of the law on purpose, right? So the more you know, the more you can go ahead and do what you need to do to protect yourselves as artists, because we need your art. Like art, when you look at civilizations, they're not usually looking at, they are looking at law, right? But they're also looking like, what was the art that was created? You are a reflection of the society that we have, and we need you. So just please remember that. And that's it. That's all I got.
Having said that, 10 minutes ago, we uploaded your likenesses and everything that you said tonight to an AI.
Fantastic.
And we blended the 2 of you
Oh,
into one new entity.
I
So
put it up on the screen.
how do you defend, since there was no contractual mention of this in your contracts? How do you defend yourself going forward?
Oh, I'm suing you for appropriation. We never agreed to this, and it wasn't included.
No, it was there. It was like the law was in Moscow. That was
You never gave us a contract. You never gave us a contract that we didn't sign. So no, absolutely not. In the case that would happen, right, I would obviously have to sign the contract first, and so would Andrej. Right? And then also we would just say that you're deceptive. So this is obviously a deceptive contract.
Did you see my email that said that I'm not responding to this email was the equivalent of signing the contract?
No. You didn't send it.
Did I not learn anything in this evening?
Forgot to send that disclaimer.
Yeah, you didn't send it.
Thank you so much.
Thank you. Thank you so much to the panelists for this insightful and truly empowering conversation. We really appreciate it. And if you enjoyed today's conversation, we will have more skills coming up. We have skills coming up on April 27th called Speaking Art World, Engaging Curators and Gallerists with Laura Berton and Owen Duffy. And then we'll also have one on May 21st called The Path to Public Art with Carola Bravo. So I hope you'll all stay tuned to our social media and our website and come back soon. Thank you so much.
Awesome.
And more
Thank
to
you,
come with
Melissa.
SIU, I'm
Thank you.
sure. So
Thank you, Oolite.
thank you.